I'm going to turn now to our private practitioner here on the panel, Gönenç. I mean, what's a bit your take? Has the effects-based approach really improved legal certainty over time? Is it easier to advise clients today than it used to be? So what's a bit your take?
Thank you. The minute something gets into the effects territory, it's never easier to advise clients because you're losing bright line rules and you're moving into a sphere where you have to do a case-by-case analysis. You don't have readily available formula for the client. If you do this, it works. If you don't do this, it doesn't work. But that's not a bad thing. And nothing easy comes in the form of effective. If we go for easy labels, typically, it leads to lack of effective enforcement in the sense that there could be a lot of false positives. Now, mushing it with the legal certainty bit of your question, of course, when there are bright line rules, legal certainty is higher. And when we were using more of a form-based approach, where we were allowed to assume that any exclusionary conduct is detrimental for competition and therefore bad for consumer welfare, when the link was established as easily and as directly, things were easier and there was more legal certainty. But this was not capturing the need of being more hesitant in unilateral conduct cases, I think, in the sense that we are guests in the unilateral conduct cases. We are very smug in our own comfort when it's a cartel case. We know that we're on the right track by enforcing as hard as possible, but when it's a unilateral conduct case, especially if we're talking about exclusionary conduct, especially if we're talking about foreclosure, we wouldn't want to find ourselves in a situation where we're defining a by-object kind of category in the unilaterally conduct sphere. If we do, that's going to lead to an overuse of presumptions. And I think it's also going to lead to a use of particular assumptions where we will be too quick to judge a change of policy of a company with a market power saying this must be the reason. I'm not even going to check the effects. I'm going to just presume the effects. When the standards are changing and when one needs to show that the particular exclusionary conduct in question is indeed detrimental to competition, it indeed has had effects in the marketplace in form of market dynamics effects or in the form of effects on market parameters, be it output, be it price. This would be a more difficult task. Certainly, it is a tad of a shift of the burden of proof onto the enforcer, or at least it's an ease for the defense counsel to shift back the burden of proof more quickly if the effects-based doctrine is being used. And that may feel like inefficient, but we should, I think, always remember that efficiency in enforcement isn't coming up with as many condemnation decisions as quickly as possible. That's not efficiency. Efficiency would be reducing the number of false positives without increasing the number of false negatives in our sense. Last sentence on this would be that in any case, I think we could all agree that false positives are particularly concerning in 102 cases. So if we're going to try to keep away from false positives, we would primarily start in 102 cases, especially in the exclusionary conduct sense, because really effectively competing may look like exclusionary conduct in the sense that that effective competition pressure may also lead to the demise of some competitors.
what's a bit the take of a private practitioner on the amendments that the Commission made to its guidance paper, and also maybe some of the discussions included in the policy brief? I mean, what's a bit your take on it, Jean?
I think the amendments have been helpful in finding a balance between the type of effective enforcement that is targeted and the legal certainty bit as well. So when we're targeting effects, taking the position that we are also going to make do with, if you will, potential effects is not a bad thing. It's not punting the ball, to use an American football terminology. It's not getting rid of the problem by reducing it to something that it's not. The court has actually opened the door, in my view, to the enforcers focusing on potential effects as well. There is no position that I can see that says it has to be actual effects. But then obviously once the amendment paper takes that approach, it becomes quite important to check which kinds of complaints of complainants will need to be handled with care, in the sense that sometimes complainants come to the agencies and say, here is the situation I'm in, this is the reason why this has happened, and I'm about to exit the market, there's exclusionary conduct, the incumbent is doing it. Now, if the incumbent is adducing evidence that shows that there is no nexus between the situation that this entity is in and its own conduct that is under question, I think if the agencies are focusing on potential effects, they should be particularly quick in checking that side of the analysis and perhaps declaring their independence from the complainant's views and saying, I don't care as much whether this situation is because of the conduct of the incumbent or not. I'm going to directly move into checking the potential effects on competition, because if I don't find any of that, I'm not going to engage in the actual effects analysis, which is much more prone to being hijacked by the parties to this controversy. Whereas the potential effects analysis can be done on a somewhat more objective basis, on the basis of the data. And it is inescapably clear, I think, from the amendment that no one is excluding factual or economic data being important in the analysis. So the amendment also embraces the fact that factual and economic analysis is in the heart of all of this exercise, which in turn means that we're not living in the land of presumptions and easy labels. We are just not constricting ourselves to a very narrowly defined understanding of effects, which looks healthy to me. In very quick terms, I would say that the change in perception about the test is good, in the sense that we all know that genuine competition can come from entities that are not as efficient as the incumbent. No one in the room ever discusses this. So there has to be a virtue of protecting that somehow. Whereas these cases very quickly were turning into shouting matches and debate contests on whether the complainant is efficient as the incumbent, and that's not healthy. We were almost entirely excluding the conduct and the rationality of the conduct of the incumbent. But the switch in the test, I think, won't mean that when the incumbent is able to properly prove that the incumbent's conduct is economically rational from the incumbent's point of view because of its efficiencies, the agency comes back and says, yes, but it would not have been rational economically had you been less efficient. That's not the ballgame we're moving into. And there's a bit of scaremongering as if we're going in that direction, but I don't think that's happening.
Gönenç, your wish?
I wish you all well. My wish is actually following Antoine's in the sense that I would wish to see the balancing of both sides of the enforcement sphere. So what's going to be a shield, what's going to be a sword, and is there going to be an asymmetry in there? Because there are some potentials for that in this particular context as well. So today at the conference we have discussed the effects-based approach to Article 102 cases, i.e. abuse of dominance cases, especially through exclusionary conduct. And in that, we tried to compare the benefits, if there were any, of the form-based approach, which perhaps admittedly brought in some legal certainty into the gameplay through bright line rules, but at the same time it was relying on too many presumptions, obviously. So by discarding these presumptions, did we do well, or did we open up the whole sphere of exclusionary conduct enforcement to certain issues of evidentiary burdens? Is it too tough on the antitrust agencies now? Could there be a balancing act? Then we discussed in that capacity the new guidelines that are going to come in and the amendments that have already come in, what they mean. In the same capacity, we have discussed the as effective competitor test. There is a virtue in protecting competitors that aren't as effective as the incumbent, obviously, and no one in the room disputed this, but at the same time, when judging the economic rationality of a conduct of the incumbent that has market power, shouldn't you judge whether that act is lawful or unlawful through an understanding of where the competitors are? Is the competitor being driven out of the market through competition on the merits, or is the competitor finding itself in a certain situation because of an artificial conduct of the exclusionary conduct of the incumbent? And in that, obviously, not all exclusionary conduct is harmful to genuine competition, so there will have to be a differentiation in that sense as well. We tried to look into the policies and principles that may enable us to better distinguish and to better provide legal certainty to the incumbents that have market power.